hasn't been much movement on the gun ban litigation at the appeals court. And there really hasn't been much movement on other lawsuits challenging Illinois gun laws. It's a brief update for you here with Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell, and wake up with us each and every weekday morning. Obviously, we've tracked the gun ban litigation ever since the governor signed that way back in January of 2023. It was a lame duck session, a bill dealing with insurance being gutted and replaced with a measure that banned more than 170 semi-automatic firearms and magazines over certain capacities. The governor signing that, saying it's needed to protect Illinois. It was called the Protect Illinois Communities Act, and signed just hours after it was passed during lame duck session. And what you had then is lawsuits filed all over the place. I mean, we can go through the background of all those lawsuits. The state lawsuits that attorney Tom DeVore filed on behalf of thousands of litigants, including gun stores, where he secured thousands of temporary restraining orders from local state courts, and those went up to appeals courts and such. Then you had Dan Calkins file his measure to challenge the law. That went all the way up to the Illinois Supreme Court. Then it opened up the door of asking questions about conflicts of interest within the Illinois Supreme Court, because two of the justices, when they were running for the Illinois Supreme Court, received $1 million each from Governor J.B. Pritzker, again, raising the questions of should they recuse themselves because the governor signed the bill that was going to be debated in oral arguments in front of the Illinois Supreme Court, and they did not recuse themselves and ultimately sided with the governor on that. And then you've got the federal cases, which were filed, 4 of them being consolidated in the Southern District of Illinois, and preliminary injunction going against the law. That preliminary injunction, which is an initial step, not the final merits of the case in the Southern District, that went all the way up to the U.S. Supreme Court, where you had the U.S. Supreme Court essentially say, no, we're not taking this case, and even saying that it's not ripe yet, and they want the final orders from the district court. Went back down to the district court, and Judge Stephen McGlynn, after a 4-day hearing, decided that yes, indeed, this measure violates the U.S. Constitution, but he put a hold on his order, blocking the law from going into effect or being in effect, and then it went up to the appeals court. Well, the latest here is that the appeals court is still sitting on it, so no movement on that case. The last entry of substance in that docket for the 7th Circuit U.S. Court of Appeals is simply, it was on December 11th of, 3 months ago, and it just says that circuit court rule, appearance by attorneys for the FFL, for Gun Save Life, Gun Owners of America, Gun Owners Foundation, Piasaw Armory, and so on. So there really hasn't been any movement in the appeals court on the Barnett case, which includes 3 other litigant groups as part of that case. So still waiting. We're still waiting on the appeals court to give us an indication of when briefs are going to be filed and when there's going to be oral arguments in the appeals court, all while we wait for what the U.S. Supreme Court is going to do with the Snopes case and whether or not they're going to take that, because we have yet to see movements on that case out of Maryland, which deals with a gun ban. But Illinois' case could get to the U.S. Supreme Court. Highly unlikely it's going to get there before the current term, so it might be, as we heard from Illinois State Rifle Association's Ed Sullivan, a 2026 case in front of the Illinois Supreme Court, and that fully depends on what happens with the Snopes case out of Maryland. So no movement there, no movement in that case. But one thing that's interesting is if it does get to the U.S. Supreme Court, and even if the Snopes case gets to the U.S. Supreme Court, could we actually have video out of the U.S. Supreme Court? Illinois Senator Dick Durbin is joining with Iowa Senator Chuck Grassley to ultimately file legislation in Congress that would require the U.S. Supreme Court to be televised. So right now, you can go and listen to live hearings of the U.S. Supreme Court, but you can't watch it. Durbin, Grassley, others, it's bipartisan legislation, would require open proceedings of the court to be televised, except where the majority of the justices say it would violate due process of one or more of those litigants. So maybe, by the time Illinois' case gets to the U.S. Supreme Court, could we have video of that, just to make it even that much more transparent? I guess we shall see. Some other cases of interest. You've got the case that Robert Beavis brought against the city of Naperville in November of 2022, and then they amended that case to include the state gun ban. Well, that case is still sitting in front of the district court. That case as well going all the way up to the U.S. Supreme Court on preliminary grounds, the U.S. Supreme Court not taking that case, and then having to go back down to the district courts to deal with those questions. And the latest we've got there is that they do have a schedule, and this was back in November when they put this schedule out. So it says end of fact discovery is going to be set for April 30th. So we are going to get there soon. Just over a month away. Disclosure, end of fact discovery by April 30th. End of fact discovery status hearing is going to be set for May 7th in the Beavis case. Then expert disclosures due by May 16th. Then you've got depositions of experts going to be conducted August 1st through the 31st of 2025. So we're talking most of this year. We're going to see various things drop in this case. But again, oral arguments in the district court case, still way far off. So how that plays out, we'll be watching that closely. So again, no real change from what we talked about months ago with the Beavis case challenging Naperville's gun ban and also the state's gun ban. What about the Cook County case that was brought by Roberto Viramontes? Well, that case is also in the appeals court and not much movement there as well. The case was argued in November, but we have yet to see any order come out from the appeals court challenging the Cook County gun ban. So that's still kind of just sitting there when it comes to the challenges against gun bans, not just locally, but also statewide. So again, not much movement there. Wish I had more information for you, but the court docket is what the court docket is. Another case that we've been trying to keep an eye on is the National Shooting Sports Foundation challenge to Illinois' gun maker liability law. If you remember this, the governor signed a measure that would allow for people to sue gun manufacturers to hold them liable for if their firearms are used by nefarious people for nefarious intent. We see that Cook County and Chicago in particular, they are suing Glock. That case is in a state court. So that's something that is going to be part of this overall federal challenge that the NSSF has against the state law. But we did have some movement here this week in the past few weeks on that case, and in particular really just motions to provide supplemental arguments. You've got the National Shooting Sports Foundation wanting to add to their packet of different cases, Platkin versus Glock, Platkin versus FSS Armory, Platkin versus Patriot Enters Worldwide, Platkin versus Point Blank Guns and Ammo, Mayor of Bloomington versus Glock, and so on. They've already entered the challenge that Cook County in Chicago has brought against Glock, just as like supplemental facts that they're going to argue as to why this case from NSSF challenging the state's firearm liability law is so important. So we did have those filed, and the judge granted leave for them to file that supplemental authority. So that's the latest in that case. Still, again, no oral arguments scheduled. When are we going to actually see that case debated in district federal court? We'll continue to watch. We do have a couple of updates here from the Schoenthal case. If you're familiar with that one, here in Illinois, you cannot carry a concealed firearm on mass transit, and that's something that was brought up in litigation in the district court. Ultimately, after interesting back and forths with the litigants, with the judge ultimately having to chastise the state attorneys for saying that his order, which says that the law is unconstitutional, blocking people from carrying concealed on mass transit, the attorneys for the state and the county came back and said, hey, after this ruling, a person opened fire and killed like 3 people on the red line, and the judge brought them into court and admonished them them saying that his ruling had nothing to do with that, and his ruling was narrow just to the 4 people who sued. So ultimately, the judge in that case siding with the plaintiffs and saying that the law is unconstitutional, but it only applies to those plaintiffs. So just make sure you're clear on that. It doesn't mean that everybody can go and carry concealed on a mass transit, but only those 4 people are. So some of the things that happen here, this is from the docket. You've got Benjamin Schoenthal and others filing captioned papers talking about different things that they need to address, and then they're going to distribute that. So this happened earlier this month. You've got a notice of attorneys that are being set up for Eileen O'Neill Burke, the new Cook County State's Attorney, different types of papers being filed, amended jurisdictional statements being filed, different amicus briefs being filed, for instance, the National Rifle Association, California Rifle Association, filing in support of the plaintiffs in this case. And then this was just last week, amicus briefs filed from the California Rifle and Pistol Association, the National Rifle Association, motions filed by Robert Berlin and Kwame Raoul to extend the time to file a reply brief. So they're looking to, again, extend the time. And we see this a lot. The state likes to request delays in getting their stuff done. But the judge granted that motion to extend, so they have to turn in their reply brief by May 2nd. So that's coming up here pretty quick as well. All right, and then you've got other amicus briefs, which are friends of the court briefs that are being filed. And what those are is just, people who aren't part of the case filing support or opposition to a position in a case. Is it used by the judge? Is it used by the plaintiffs? Is it used by the defense? Obviously something that does sway some things, but just how much is up to debate. So again, just an overview here of the status of various challenges to Illinois gun laws. So the Schoenthal case, the mass transit ban case, looks like it's moving, even though the state wants to delay their response. Looks like in May we're going to get that response. So we'll be watching for that. And then you've got just stagnation in some of these other cases, including the challenge against the state gun ban and the challenge against local gun bans as well. So there you go. It's is it an update you wanted? Just so you know where things are at. I hope that it helps you out on this Friday here with Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. Wake up with us each and every weekday morning as we bring you the latest you need to know. Get the headlines at thecentersquare.com and join us as we go live. I'll be off this weekend. We'll be back at it on Monday. It is Illinois in Focus Daily.